Hi, good afternoon. My name is Terry Bankert. I'm a downtown Flint attorney, 235-1970, 235-1970. If you're in need of some serious family law questions, consider giving me a call. The initial consultation is free, 235-1970. What I'm going to talk about today is just one piece of family law. And what I use are unpublished Court of Appeals opinions. Why? Well, there's no stare decisis, look it up. More importantly, they're written by some of the best people in the state, and they're current. So today, and I'm not going to mention the parties' names here, they probably have enough exposure. But this is an unpublished Tuscola County Circuit Court case that went to the Michigan Court of Appeals. And it was unpublished January 21st of 2020. And I'm not going to go into the facts of the case. I'm not going to apply them. That's lawyering. I'm not going to reinterpret what the court did. I'm simply going to use the black letter law that they cite to make you aware of it so you know a little bit more about it. This might be a little bit longer than what you might think it should be. But here's what it is. In this case, from the Michigan Court of Appeals, that's probably backwards, isn't it? In this case, there was a current order governing the custody of a minor child. The party moving to modify the order must prove either proper cause, mom's a meth head, or change in circumstances, dad moved, sufficient to warrant reconsideration of the custody decision. It's cited if the moving party, establishes a proper cause or change in circumstances, the trial court may modify and establish custodial order. Okay? Proper cause or change in circumstances, bad stuff or changes in everybody's life, or the pattern and practice that you've recently used in parenting time or custody. If mom has sole custody, but the child's with dad for 6 months, that's change in circumstances. If mom or dad goes to prison, that's proper cause. And then the trial court, the court you're in front of here in Genesee County, may establish an established custody order, may modify an established custody order if the trial court determines that the modification is in the child's best interest. Okay? Child's best interest. Those are magic words in family law. There's a state statute, 722.23, that has 12 variables in it. And we want judges to tell us how they make these decisions. And they're called the best interest decisions. So they take the facts and apply it to the best interest and say, whoa, I see here that it's for mom, or I see here it's for dad. But more often than not, it's for both of them. But you have to argue those elements. And in front of some referees around here, you have to say the magic words. Really? When the trial court determines the modification would modify the child's established custodial environment, another term of art, seriously big deal, established custodial environment. Where does the child think they live? Who's the child turn to for care and comfort? When a child's scared, who do they run to? But more importantly, where is the child living now, with which parent? The trial court may not modify the current custodial order unless the movement proves by clear and convincing evidence that the modification is in the child's best interest. Okay. Then there's a case called Shea where the trial court determines that there's no established custodial environment. The moving party must prove by a preponderance of the evidence. Okay, that's the difference between a traffic ticket and a misdemeanor charge. That's close. Where the plaintiff does not challenge the court's conclusion here, in this case, that an established custodial environment existed with both parents and that therefore the trial court to modify the custodial environment must find by clear and convincing evidence. That's a lot. It's not a murder charge beyond a reasonable doubt, and it's not a traffic ticket. Preponderance of the evidence. It must find by clear and convincing evidence that the change was in the child's best interest. Now, it's just not their definition of best interest like their Quaker family grew up believing, but it's the best interest determination as outlined by the state legislature, your state legislature, in the state of Michigan. So we know how these guys and gals make their decisions. So we can appeal what they say, or we can support what they say. The plaintiff here also argues that the trial court committed error requiring reversal, and after reviewing each best interest factor, the court used the phrase, the referee did not err. So what the court did is it viewed the paper version of the referee's findings and found that in analyzing the best interest factors, it upheld the referee, which is just another attorney hired by the court. So that's why best interest factors are important. Established custodial environment is important. And the burden of proof, the doorway, proper cause, or change in circumstances are important. My name's Terry Bankert. I hope this helped. This is a little bit longer than usual. I liked it. You're supposed to keep these at 3 minutes or people will go away from you. But if you liked it, please let me know. My name's Terry Bankert, 235-1970, 235-1970. That's my moneymaker number, so I'll give it to you again. 235-1970, area code 810. Thank you very much. Yeah. Here I am struggling to turn this off again. I hate it when this happens. Okay, I can do my stand-up comedy routine. Okay. Ooh. Hey, come on in. You might as well get on this too, because I can't turn it off, which means this one isn't going anywhere. Come on in. Where are you going?
Clicking.
Oh, yeah, okay. See?
Where's your mouse?
Yeah, I gotta do that. See, that's, I tried, was I supposed to do that? I was trying to use my finger and it didn't work. Hi, this is still live streaming. How are you all doing? Okay, I have a mechanical failure here. Okay. So, I'll try using the mouse instead of my big finger. Like right there. Bingo. Yes, I do. Absolutely.